Letter from Attorney Seok Dong-hyun to all domestic and international journalists, broadcasters, reporters, and panelists. The insane situation currently unfolding against the sitting President of the Republic of Korea, orchestrated by the Corruption Investigation Office for High-Ranking Officials, CIO, in collaboration with the opposition party and other allied groups such as the Korean Confederation of Trade Unions, KCTU, also known as Minju-Nochong, will soon be recognized as completely illegal and invalid in both its procedures and substantive matters. I hope you will be able to understand the situation accurately instead of making mistaken judgments. The emergency martial law declared by President Yoon late at night ended the following morning, even before the sun rose, in response to the National Assembly's request for its repeal. After the National Assembly hastily concluded that President Yoon was guilty of insurrection without a single day of investigation or a single hearing, and then decided to remove the charge of insurrection from the grounds of impeachment when the Constitutional Court began its proceedings. President Yoon was impeached. The prosecution, police, and CIO, all appointed by the president, began arresting the highest-ranking military and police officials, who had simply followed the president's orders as if a starting pistol had been fired. Rather than conducting an inquiry after removing them from their posts, they immediately sought arrest warrants. Likely because the judges, faced with the graveness of the matter, found it difficult to dismiss them. Without having resolved the complex legal question of whether the charge of insurrection was applicable, the warrants were issued. Since then, I have been answering numerous questions from hundreds of journalists, domestic and international, who have been asking about this situation, either through direct interviews or via text messages. In this situation, I feel like a correspondent in a war zone, standing in for President Yoon, who has effectively been confined to his residence. The Republic of Korea is already one of the world's top economic powers and is a nation that values democracy and the rule of law, which everyone, from the president to ordinary citizens, must adhere to. The media is portraying President Yoon as the only person not following these legal principles. But is that really the case when viewed more objectively? Is democracy and the rule of law truly being upheld in South Korea today? Where has the principle of presumption of innocence, which the opposition party has always emphasized, gone? And where has the careful deliberation shown by the court in the ongoing trial of Lee Jae-myung disappeared? Let me make it clear. I would have unequivocally opposed President Yoon's declaration of emergency martial law in advance. While it was a measure of last resort that the president likely felt he had no other choice but to take, considering the high level of democracy and political awareness among our people, it was deeply regrettable. However, that does not justify the situation where the president, elected by the people, is immediately presumed to be guilty of insurrection without due process. His powers are suspended, and he is arrested and paraded in handcuffs before the world. Please do not be misled into thinking that the arrest warrant issued by a single judge from the Seoul Western District Court, after a brief review, somehow validates the legality of CIO's investigation into insurrection or constitutes a sound judicial decision. Consider this, even after years of trials, opposition leaders have often refused to recognize final rulings by the country's highest court. Many Supreme Court decisions have been overturned or declared void by left-wing forces. Legal interpretation and determining the validity of actions are not simple matters. If such mistakes occur, the consequences may only affect the individuals directly involved. However, if there is an error in the legal process against the sitting president, it is a grave matter for the entire country. I am confident that the majority of legal professionals in South Korea, unless they are ideologically biased, will recognize that CIO does not have the authority to investigate the president for insurrection. They will agree that CIO's actions, including forum shopping to have the arrest warrant issued in violation of legal procedure, are clearly unlawful. If the arrest warrant is blatantly illegal, legal professionals will understand that it is perfectly lawful not to comply with it. This issue is a clear call for Korean legal professionals, regardless of their opinion on President Yoon's declaration of emergency martial law, to speak out against the signs of the collapse of the rule of law. I urge journalists to consult with legal professionals you know, or even investigate the matter yourself. If you do so, you will find it difficult to ask why the president rejected the arrest warrant or resisted CIO's attempts to arrest him. CIO, which lacks the investigative experience and personnel of the prosecution, is overstepping its bounds by investigating the sitting president for insurrection, an offense that does not fall within its jurisdiction. How can CIO so boldly disregard the law, shopping for courts and judges that fit its agenda, issuing arrest warrants as though they are sacred, and attempting to arrest the president as if it were their sole mission? Moreover, CIO, in collusion with the police, has summoned the head and deputy head of the Presidential Security Service, accusing them of obstructing the execution of the arrest. High-ranking officials tasked with protecting the president's security are being treated as criminals simply for doing their jobs. The Vice Minister of National Defense and the Commissioner General of the National Police Agency are even interfering with the president's security operations. Furthermore, the head of CIO, emboldened as though nothing can stop him, reportedly sent an official letter to the acting president, requesting assistance in arresting President Yoon. This is truly shocking and unthinkable. Has any powerful prosecutor in history ever sent a letter to the president requesting help to arrest a ruling party official or suspect? This has never happened, and it is unimaginable. I strongly urge journalists and panelists to take just 30 minutes to read the CIO Act at least once. This is a law created by the Democratic Party, and you will see that insurrection is not even mentioned in the law. CIO claims that because it can investigate abuse of power by President Yoon, it can also investigate him for insurrection. However, according to our Constitution, even the investigation of abuse of power by the President is not allowed. Article 84 of the Constitution stipulates that the President shall not be charged with a criminal offense during his tenure of office except for insurrection or treason. Thus, the investigation into insurrection being conducted by CIO is clearly unlawful. Why, then, is CIO acting so recklessly? Why did the head of CIO and some of its staff have so much confidence to disregard the law? The answer lies with your judgment. Seok, the 5th of January, 2025.